well, holidays.
Yes.
Welcome, folks. This is House Corrections and Institutions. It is Friday, May 22nd. And we are on S-193. We have with us Ledge Counsel and also the Chair of the House Judiciary Committee to go over a proposed amendment that the House Judiciary Committee is working on S-193 that also impacts some of the pieces of the work that we did in our committee on Section 5 and Section 7. And if someone again could move those tulips so I could see.
Metaphorical. That's my job. It's either.
I mean, but there's a little ragged. And it was kind of framing your face a little bit there. So anyway, so I'll turn it over to you if you could identify yourself for the record and walk us through the proposed amendment.
Yes, happy to. Good morning, everybody. Eric Fitzpatrick with the Office of Legislative Counsel, and as the chair said, here to talk with the committee about a proposed amendment to S-193, the forensic facility bill, which I'm sure the committee has been very familiar with over the last few weeks, if not months by now. Just for a moment before we look at the language, just to let the committee know the structure of this proposed amendment and what the idea is that you remember that a lot of the language that came out of this committee, for example, in different places in the bill, put some guardrails on the involvement of the Department of Corrections with the forensic facility. Some specifics about, for example, providing security at the admitting area and around the outside perimeter and that sort of thing was what this committee had been working on that language. Now that language will still be in the bill. It's still in the sections of the underlying bill S-193, but it won't become effective until July 1st, 2029. And in the meantime,
It's been delayed because the bill right now is July 1st, 28 for the forensic.
yeah, that's been
Extended out one more.
one more year, exactly. And during that interim time, that's when, and you remember this issue had also been at least addressed a little bit and discussed in this committee, which is, well, what happens in the interim, right? Because there's still folks who would need these services. So what happens until the time that the forensic facility comes online? And so what the proposed amendment does is it puts in something that had been in previous versions of the bill, which is requirement, look, now is emergency rulemaking. So it's going to require emergency rulemaking by the Agency of Human Services to put this interim forensic program and competency restoration program in place. And during that interim period, which is July 1st, 2029, what's that, like 3 years roughly from
Well,
now?
that's what I want to, well, right now, when we were doing the interim, it was basically from the time from July 1st, when the law, when it got signed, when
This year.
this year.
Yeah.
The interim that we were looking at was from July of this year to January 1st of 28, because that's when the forensic facility was going to be starting to be established. It might go a little bit beyond January 28. So what the amendment does, it extends that interim period by 1 year to January 1st, 29.
Actually, July was year and a half,
It's
8 months.
July 1st.
Yeah.
Yeah, it is. I read it right here. July 1st, but it extends it out a year and a half from what we had. And then the emergency rules will occur from this summer, and they need to be in place by December of this year,
Yeah.
which then means that the interim restoration competency program will take effect January 1st, suppose, of 27. It will be in place until July 1st of 29.
That's right. Yep.
So it extends the interim period time by a good year. But
Right.
what the bill was.
Yep. And puts these emergency rules in place so that standards and guidelines for this interim program get put in place, that they would last. And in fact, those emergency rules themselves sunset July 1st, 2029, because it's at that time, that on July 1st, 2029, that the language and provisions that this committee worked on, in other words, I mentioned at the very beginning, the limitations on DOC involvement, those sections, as I say, those remain in the underlying S-193, but they spring into effect on July 1st, 2029, at the same time that the rules go away. Because the presumption is, again, we'll see what happens in reality, but the presumption is that by that time, facility's up and running, you don't need the emergency rules anymore. The statutes that limit DOC involvement can all go into effect. It might remind the chair of something. It certainly reminded me of something. It reminded me of Raise the Age. It's a similar kind of concept.
So for the rules, we got the emergency rules for the interim.
Yep.
So then the forensic facility would, come July 1st of 29 is when the work would be to establish the secure facility.
Yep.
But that's when rulemaking for that secure facility would then start. Because that's in the definition of forensic facility. There's no rulemaking that will occur
Not for that, you mean for the permanent facility?
for the permanent. Because what is in the bill in section 5 on the definition of forensic facility, the Secretary of Human Services shall adopt rules pursuant to blah, 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 to implement this section.
Right.
So that would start happening in July 1st of 29.
Yes. Although the presumption was that they would have had these emergency rules for quite a period of time. So that, in other words, they wouldn't necessarily be starting from
The
scratch.
emergency rules only deal with the interim, which is in the interim and services
different.
being provided. Because those emergency rules in the interim would also cover DOC's monitoring of folks in the community.
Mhm.
So those rules sunset July 1st, 29.
Right.
And then the new rules for the facility and the whole operation of that starts July 1st, 29. Because that section is effective July 1st, 29.
Right. I think that doesn't.
So there'll be a gap there.
Well, there will be a gap before the rules would be, say, reviewed and finalized by ELCA. I think it permits the rules, like presumably they can be working on the rules before July 1st, 2029. They know that it's coming up. But you're right, they wouldn't be, the statutory language requiring their development wouldn't go into effect until then.
I read this very quickly. Is there anything right now in the interim period that requires regular checkbacks about how what do I want to call them? The eventual facility is being contemplated? Meaning, are we requiring the administration to give us regular updates? I'm talking like every 6 months, not once a year, during this interim period on the development of the forensic facility as contemplated in the feasibility.
There is at the outset, that would be on page, well, the amendment is but it leaves the underlying section in place. But if you look at the amendment, page 2, it's the third instance of amendment. That's referring to the updates that come back to justice oversight.
It's all.
Yeah.
But you may think about whether or not you want to.
Here's my worry. Again, I read this very quickly. I'm probably going to need some time before I can make a decision on whether or not I can support it. And same worry I articulated yesterday to you. There is nothing in here. Once we get this interim period going, and I'm fine with the interim period. I know we have to have something in place right now. There is nothing in here that then holds the administration's feet to the fire of working on a legitimate, clinically driven forensic facility. And the interim period conveniently ends at the end of this administration. So it would be really easy for this administration to drag their feet on that development of a sincere and honest forensic facility and just hand it off to the next administration. very easy. I would like to see regular conversations in these committees about the development of a legitimate forensic facility while this interim is working.
Yeah, Martin Malone, representative from South Burlington, Chair of House Judiciary Committee. So I agree. And my concept of this was we need to see what this feasibility plan comes back with, and presumably January 15th or soon thereafter, these committees, yours and ours, are going to have the folks in to explain what this is and can establish from there, presumably, when the rulemaking, because there's gonna have to be additional rulemaking afterwards, and can establish the check back period when we see that, because we may see the feasibility plan and say, this is not it.
And that's my worry.
Right.
And
So
all we have is this interim plan, and that then gives the administration the ability to say that's good enough.
Right, so, but I think, I mean, I'm not opposed to putting some sort of report back in this, but I was thinking that we could see the feasibility plan first, which be like the third week of January. Don't schedule for.
It's coming January, right?
Yeah.
Yeah,
Coming
yeah, so.
I mean, we would have, and I think that's part of our thinking, feasibility plan, get it? You got till the end of the year, the check-ins with Joint Justice Committee, so that you've got the respective chairs of the committees, House and Senate, that are working on this issue on joint justice. So in the off session, you can see what direction that feasibility plan is going. And joint justice can continually give feedback. No, that's not where the legislative intent was. Then comes January, new session. You continue that work based on what the feasibility plan proposes. The question then becomes, what occurs after next session finishes up? What occurs during the summer of 27? And do we want to address that now? Or do we address that next session when we have a little bit more information in terms of what the feasibility plan is for that?
That was my thinking. Discussing feasibility plan. So.
James?
I was just gonna say, I agree with Martin's rationale, that you look at the feasibility study when it comes back. Our plan, when it comes back in January, and go in one direction or the other based on what we find, we'll have that opportunity. Now, if that wasn't there and we're just skipping all the way to 29, I would definitely feel differently, but coming back at 27 and saying, hey, this is what our plan is, and then we have plenty of time during the legislative session to make those pivots.
Does that make sense, Troy, or would it be?
It makes sense. I'm not taking the same leap of faith that others are right now.
So, I'm just wondering, would it be helpful? And we've done this a few times with joint justice oversight, that they would make a recommendation to the standing committees. We've done that in the past, where on the feasibility plan, on our section 7, page 27 of our bill, or of the bill, on August and November of this year, the agency needs to present where they are in the feasibility plan to joint justice. And also what the amendment before us is also stating that they also need to report on the emergency rulemaking, where they are. If we added language that the committee, Joint Justice Committee, would make a recommendation to the standing committees on how we move forward. Would that help at all? Or be silent? Other folks, do you see what I'm saying?
See what you're saying. I don't know that it does anything that isn't, I think there's a presumption already. Faith in the two of you to be in that room and come back with an honest discussion. I don't think we need that in language. I'm just trying to get something in here now that prevents the administration from dragging their feet,
Prevents the administration from what?
dragging their feet
Dragging their feet.
until 29. That's just in my head. We don't have to figure this out. Like,
I mean, that's
not-
really imperative of the members who are sitting around this table next year
Mhm.
and House Judiciary next year to keep their feet to the fire. And
That's-
what direction we go in.
So thank you for that. Because my job is right now. Like, I'm no guarantees that I'm in the room
Right.
a year from now or 6 months from now, right? My job is right now. And how Loctite can I make this bill to ensure that we're moving in a direction further than and substantially different than the interim plan that has these treatments happening in our facilities that are not therapeutic, that are not clinically driven. So right now, what can I get into this bill to make sure that happens, rather than that leap of faith that you're asking me to make, that I don't know that I can do. Yeah, I don't know if there's an answer to that.
Yeah, there's not a,
There is some,
I think that kind of the best answer is that this plan is coming back to us. It has to be delivered to us, so it will be in front of us.
Yeah.
To see where they're trying to head. So,
and that's why the forensic facility language in terms of when it becomes effective is not January 1st, 27. It's extended out to give time for two legislative sessions to weigh in on it. So that's what you really have, is two legislative sessions to weigh in. Sean?
You know, forgive me, I guess. I see where Troy, we're trying to do, but are you trying to legislate two ahead of time in a way that we're not supposed to be able to do that?
I don't think I am, no.
You need to find a future legislature.
Right. Is that where we getting, like, is that a problem?
Now that we're just asking for report backs, but I hear Martin's point that, what are they gonna report before they have to?
and I think we're trying to bind the administration.
Which is,
Which this is a constant struggle
Right.
of dealing.
Yeah.
Right, executive branch.
okay, I'm sorry, thanks for making that distinction, Mark.
Is it oversight or is it binding? I think it's oversight, but
Let's continue on the
Yeah.
amendment and maybe I'll bring some other things.
Okay,
Chair, before we go on, I was gonna ask, are there any time constraints? I know some of us have a 9:45. Does Ledge Council have to? Got a date?
Oh, it's, we're on the same, it depends when we walk down the hall together.
Okay.
That committee is waiting for this committee.
All right, all
We
right.
do have a signing at 9:45.
Very good.
Okay, let's keep going.
Okay. Well, we were still talking big picture, which I think is good, because that sort of makes the rest of the discussion a little bit quicker, because you sort of have all these big picture principles in the backs of our minds. So let's then turn to the language of the amendment itself. And that is, so is everybody looking at a version 3.1?
Yes.
All right, and from Representative Burdett et al. So you'll see the legislative intent language, and the only change here from what had come out of this committee is that it adds that date on lines 10 and 11. You see that it's the intent of General Assembly shall establish this facility by July 1st, 2029. Because remember, that's the new new proposed effective date of the permanent facility. You still have the language in here, that second sentence that I think, if I recall correctly, came out of this committee substantially, that sentence about DOC's limited role in this thing. But again, this is with respect to the permanent plant facility, not the interim, because that's the distinction between the two effective dates. All right, second piece really starts.
Can I just
Yeah, please.
articulate an appreciation, because I know that second sentence was struck as of yesterday. Right,
That second sentence.
so I appreciate that coming back. Thank you.
Oh, which,
Lines 13 through 17.
okay, yeah.
And Burdick's original amendment was struck.
Thank you. Just
You
a
bet.
moment of gratitude.
I'm happy to pause anytime, so please interrupt with any questions. The second instance of amendment has to do with the feasibility plan. And again, much of which came out of this committee originally. And the change it makes here is that the bill came out of the committee, the feasibility plan, again, had some, and this particular part of this feasibility plan has to do with the interim status, the interim program. You'll see that on lines 18, well, I guess lines 2 and 3 of page 2, because this is about while the development of the forensic facility is pending. And in that situation, remember, this is going to be addressed by rule. The interim idea is addressed by rule, but you wanted to keep in here, if I understood correctly, some language that had been in your proposal, which is that, well, while this is pending, the issue would be addressed of placement in an out-of-state residence where clinically appropriate programming can be provided. So that language was in your language as it came out, but
That was 12A.
yeah, exactly. But the language that was, again, putting those guardrails up around DOC, that is struck here because this has to do with the interim program only. And it's during that interim period when the idea is to permit DOC some extra level of involvement, but that goes away in 2029. All right, so that's the second instance of amendment. Now, moving on to the third instance of amendment, which is also related to the feasibility plan. And this is, I think, the chair, you mentioned this earlier already, which is the idea that the rules have to, or sorry, the feasibility plan has to address not only the implementation of the interim program itself, but also on the emergency rulemaking. So you want to hear back from the administration at Joint Justice Oversight on this emergency rulemaking that's supposed to be going on. So that makes that clear there. All right, so now we're moving on to the fourth instance of amendment, and this is one of those situations where this version of the language, you'll see, for example, if you look at,
Where are you at right now?
I'm starting at the fourth instance of amendment, which starts on page 2, line 8. Yes.
Okay, thank you.
Yeah.
I got you.
Yeah. Yep. And so this takes this section. This section is not new at all. Yeah, it's just, and I'll point out where the differences are though. But this is the section that basically involves the court procedures for someone who's been found not competent to stand trial and then is placed in the forensic facility. So if you look at, let's see it, subdivision 5A, which is on page 6. Oh, sorry, page. Yeah, no, that's right, page 6.
Of 7.1.
Yeah, no, page 6 of version 3 of the amendment, 3.1. No, that's okay. Page 6, everyone with me there? Okay, so if you look at page 6, line, so it kind of goes over, well, bottom of page 6, line 21 is the last line. It's going to continue on to the next page. This is the situation where the person has been found that they're not restorable, they're not dangerous, and they have to be released on supervision. That's what it's required. They have to be released on supervision. That doesn't change. That part stays the same. But the question is, who supervises? Now, remember, as it came out of this committee and in the version 7.1, actually, the Department of Corrections was not listed there. The new language, you see, look at the bottom of page 6, line 21. Here at supervision, and then it says by the Department of Corrections in collaboration with, turn over the top of the next page, in collaboration with Commissioner of Mental Health, Dale, et cetera. So the added language is DOC in collaboration with. So as it came out of here, the only departments involved in the supervision were DMH, Dale, et cetera. This as, hey, DOC does it in collaboration.
Didn't we have in consultation with the OC?
No, it didn't have DOC at all.
Collaboration.
Actually, the language out of here didn't mention DOC at all, the final language.
7.1.
No, it's in the feasibility plan that we had. Developed in consultation with DOC. It would be those residents that were discharged, community monitoring plan.
Yeah, develop.
Each department with custody of individuals in the forensic facility.
That's it, because
Developed in consultation with DOC. So here we're putting DOC as the lead.
and they don't have custody.
They don't have custody. These folks are detainees.
Well, I think that these folks have pending criminal charges against them and they could be in custody.
But they're not a detainee. When they're released from DOC, they're not in custody of DOC. When a detainee is released right now,
Right?
they haven't been sentenced. They go to court. They've been held. They go to court. That sentence could be resolved. They could be let go.
Right. But in this
But
instance,
DOC is not overseeing them. So how is that different from someone whose competency cannot be restored? They can't go to trial and then they're released.
I think the distinction here is that and I mentioned this in the other committee as well, that in some sense, the custody isn't the issue. It's the supervision. They're not, these people are being released, and, custody wasn't used in the prior version either, when it was Dale, DMH, et cetera. It was just supervision. When they're being released, they're under supervision. And it's those supervisory,
No. In the feasibility plan, on the 7.1 draft pad, page 26, a resident discharged and community monitoring plan for each department with custody of individuals in the forensic facility, developed in consultation with DOC. That is language we put in the feasibility plan to come back to us and figure out how you were going to monitor these folks in the community. It was not driven by DOC. It was driven by the department that has custody over the individual.
right?
This-
That's the feasibility plan for the permanent facility, right?
Right. But
This is only this is not permanent.
I know it's in the interim.
Right.
But you're putting DOC in the lead
Correct.
to monitor these folks in the community that they have no custody over. You're putting them in the lead. So this is a point of contention, I think, with the members of this committee. And how much information does DOC have in terms of the actual treatment that the court has set those conditions for that person? How much control does DOC have over that? Or is it the departments like mental health and Dale that have control over that? Because DOC doesn't have information in terms of what their risk status is. Who's doing the risk evaluation? Because when PMP supervises folks in the community, there's a risk evaluation that is done so DOC knows what level of supervision they need to do. So how is that put in place here in the interim?
That's addressed, at least if you're talking about information sharing, that particular piece of it is in the rulemaking. So if you look in the emergency rulemaking, your version would be toward the very end.
Yeah.
Yeah, so if you look at page 24, lines 4 to 6, subdivision 3. So the emergency rulemaking has to address that, the manner in which DOC would cooperate with and obtain necessary information from other departments about persons released under supervision from the forensic program. So again, that rule comes into effect, well, the emergency rule is in effect by December 31st of this year. And then based on that language, they have to address the issue that you just mentioned.
So who does the risk assessment for these folks? So that DOC knows what level of supervision.
It's in the section 2, and it's done by, overseen by the AHS medical director.
Because that's an important piece, because DOC needs to know what that risk level is to determine what type of supervision. Is it a daily check-in? Is it a phone call? Is it actually visiting the resident? Is it putting on an electronic monitor bracelet? Those right now, that's how supervision in DOC's world and the community right now operates.
Right, so you'll see on page 5 is where it talks about forensic risk assessment for individuals, which could be looked at for determining whether and how to release the person and under what orders.
Yeah.
And I just need to make one other comment real quickly, that's that as far as custody is concerned, in my discussions with Dale, the only people that they take custody of are intellectual development, intellectual disabilities. They don't take actual custody of people with Alzheimer's, traumatic brain injury, all those. So it's like we're having them supervised, even though they don't officially have custody of those particular individuals. It's not in their statutes.
And what about the Department of Mental Health? Do you know?
They generally take custody if they're hospitalized. When it's an ONH, I don't think that's actually considered custody. They barely monitor. And that's one of the reasons, as I've expressed here, that DOC actually does know how to supervise and monitor, and we don't have a whole lot of faith that that's the case with DMH. Or at least not yet, but hopefully.
I mean,
By
that's the same
2029.
concern I have about DOC supervising this population. That have the capacity and the training, and this is a different type of person being supervised than somebody released on criminal charges. There's an added level of monitoring that needs to happen that I am not convinced is present in our P&P staff or the training of the staff.
And that's why it's in consultation with Dale, DMH, and the like.
That was put to that. In consultation with the Department of Corrections. Supervision shall be,
Yeah, the language is DOC needs to reach out to those folks.
Yeah.
That's the way the language is. Our version in the plan was flipped. They weren't, the DOC wasn't in the driver's seat.
But for the long term, it's still that way. This is just the interim.
We know that. You know, this
it's
is.
still, yeah, it's still a problem for us.
That's
I can get that. I just want to reinforce that it's not forever. And I think a lot of us would disagree if it was forever.
So, I don't mean to be antagonistic. Why would you disagree if it were forever, but not for the next 3 years?
I think there's a partial, if you will,
Yeah.
and it's that very loosely system in place that they're trying to maybe formalize. And that this will be, this amendment helps get everybody who needs to sign on enough numbers to actually get it through to the finish
I
line.
get that.
And that's,
I'm worried about the foothold we're creating.
yeah, and I would have a lot bigger concern if we didn't have a opportunity next year, which we do, whoever we is, but I am not willing to let it be yet another year of not having this move forward because I want perfect. And my version, as we've already talked about, is much stricter than even what we've talked about, but we're not gonna get it. And I would rather have something that we can do as long as the pieces are there that say, hey, this is not long-term. You will be doing X, Y, and Z long-term. That's me, because I'm not trying to convince anybody else of that. I want it to pass through the finish line and get a signature. So we have something that's better than we have.
So I guess the answer to you, Troy, on that is that my concern for this interim period, as it will be going forward as well, is the public safety side of this. And DOC is more in line for being able to provide that. If we're going to be having the system where somebody who's been charged with a life offense, who we're going to have in the community under this being supervised, public safety, I think, for the community to accept this needs to be front and center. But we do need to understand that it's just as critical, and I'm from people we talked to and had in, that there has to be the supervision in conjunction with the providers like DMH to make sure that people are taking their medications and all those things. And if there's more that we need to do on the rulemaking to make sure that we have that right, we do have that language that we put in there, given your suggestions yesterday. So that's the perspective that's coming from.
Can I ask one more question on this? Eric, we had deliberate language that the folks making these evaluations are separate from anybody contracted by DOC, which is WellPath right now. Is that separation still in place?
It's the agency's medical director, right?
Yeah, but what's keeping them from just contracting with WellPath? That's my question. I don't want the same people who are charged with providing care to incarcerated folks making the decision about should these folks stay incarcerated or under the supervision of DOC. I want it to be a separate
There was an explicit line there, right, that I don't know is still here.
It's not under the contract, not currently contracted by the firm.
No, I think that is a line that for the interim piece is removed by the Burnett Amendment, I believe. And I think that's the piece where the part that's kept in is the out-of-state placement, right? So it's in the second instance of amendment, but it takes out the.
So I'm looking on 7.1,
Right.
I'm looking on page 27, top of
Yeah.
27.
Right, that's number 12, right?
That was 12B.
Yes, 12B, exactly. So, yes. In answer to your question, that part is not in the amendment and therefore would not be in the interim
Martin,
plans.
get that back in there?
Because that was a big point of contention. We wanted to make sure that any programming that happened within the facility was not done by DOC. We wanted to make sure it was clinical programming that was provided outside of the DOC contract with WellPay. That was really important in this committee, and that would be a deal breaker. That language does not go back in, that the clinical, that the,
So it would be contract with a check contract with, because again, the scenario is that it is in DOC in the interim, it's in Springfield.
in our language was that as well. And we said competency restoration program within a Vermont correctional facility. That was our plan for the interim restoration program, provided by an entity that is not under contract with the Department of Corrections.
So I think that where that would probably fit is in section 12, emergency rulemaking. Even in that first paragraph of section 8. Is that, I think that that's where that language. Yep.
You don't just want to strike the second instance of amendment in its entirety.
It was-
You could do that if you just want to put it back in.
Did you say page 12 or section?
It's the
Section 12, page 23 on.
that's the instance of amendment that removes B.
But I think it has to be in the emergency rulemaking.
Take it over.
That you build.
Yeah,
Yes.
yeah, you don't want to, yeah, you want it in the rulemaking.
Yeah, just the way that subsection A of section 12, emergency rulemaking, it seems like it would fit. Right there.
Right. But it isn't now.
It's not now.
Right.
But that language,
So you're saying strike the second instance of amendment, but instead put those two concepts in the emergency room.
No, I'm not saying strike, keep the second.
Yeah, you don't, still don't need 12B. But we do need that specific,
You need the concept of 12B
yeah.
in the room.
what you need to make sure is that the program, the competency program in the interim is being provided those folks who are in an incarcerative setting, that program is being provided by an entity that is not under contract with the Department of Corrections.
And that will include the determination of somebody becoming non-restorable, right? That sort of program.
That's, yeah. that's part of
Yeah.
it. That's the whole thing, right?
That's why we want that separation.
Yeah.
See what we're saying, Eric?
Yeah, I do. Thank you.
And what you're saying, Martin, is put that in section 12 in the rulemaking.
Yeah.
And then joint justice oversight would be hearing about that in the interim. It's really important to have that language in there. James?
Martin, I like that language. We've wanted it in here. Do you feel like there's going to be any contention in your?
I'll raise it over there.
Okay.
I don't think really, but.
Okay.
Let's speak for.
I mean-
I will. Explain your very.
Okay. I just,
And if this is,
I didn't know we had a feel. No
make
big
you
deal.
comfortable enough to. This along.
I mean, we're all in agreement. We need to do something in the interim.
Yeah.
We're all in agreement. And we've all been looking at, and, I go back to what Representative Eric McGuire said, you got to provide those services. You got to separate DOC's role of security and the clinical work. And DOC is not equipped and should not be doing the clinical program. You need that separation, and we want to keep that separation in the interim.
And the community.
So I have a question about this. So do we also, is this already still here?
She gave me that.
Or we had the provider that's doing the,
Kind of teed it up.
is providing is also, is different than the one that's basically doing tests, right? You know what I'm talking about, Troy? That's what we're talking about, making sure those are two different entities.
Yes.
Okay.
Yes. And it sounds like we're gonna try and put that in.
In rulemaking, as the rules are, emergency rules are being developed, they have to check in with joint justice.
Thank you.
And Troy will be watching joint justice.
Like a hawk.
They come down.
It may come down. May even let you speak from the audience. Okay, we've disrupted enough. So Eric, where are we?
I believe we're on page 6 and 7. We just sort of talked about this. This is a discussion that the committee's just been having about the DOC role. And I think where we landed was that we're going to make clear in their emergency rules that recognizing that for the interim, here it's DOC in collaboration with the departments, and that's page 6, line 16, as well as page 7, lines 1 and 2. Also page 7, line 7. Here's it's the supervision of the Commission of Corrections. So all those things are part of the same change, but it's going to be addressed by having the emergency rule make clear that during this interim period, the contracting entity can't be somebody, the service provider isn't someone who's under contract with DOC, as the language was when it came out of this committee. So that really covers the only change, you'll see there's a lot of unchanged language. That is because I understood that the preference was, rather than having instances of amendment, just to see like one line, three words take the place of those 6 words,
Yeah.
to repeat the entire section. So that's why it's all here. There aren't actually any changes until you get to page 10. All that stuff is exactly the same as it was before, until you get to page 10, toward the bottom, subsection G starts on line, actually, we're gonna have the version.
E,
Pardon me?
would it be E?
Okay, yeah, that's right. All right, I was looking at the, thank you. Top of page 11. That's where subsection G is, and that's where the next couple of changes are. And it has to do, again, it's similar concept though. And in fact, it's exactly the same as what we just talked about. This is talking about supervision when the person is released, when they're not dangerous. In this case, it's a different population because in the other case it was in certain cases having to do with dangerousness. But here, when they're determined not dangerous under supervision, you'll see that it's the Agency of Human Services medical director is the person who's doing the supervising here. But it's in consultation with these departments. And again, it's the idea that if there are conditions of supervision that, for example, going to your appointments with your counselor, make sure your medications are up to date, whatever that may be. I think the concept was that you wanted the supervising person being the medical director, making sure that that's what's going on. So they're consulting with the appropriate department. The medical director monitors compliance. And then it's the medical director, that's the very bottom. Upon request from the Agency of Human Services medical director, the court orders return of the person. And then it's once the court orders return of the person, that might not happen right away. It could be a day or two, or it could be longer. But then once the person does get back to the facility, this is subdivision 2, medical director notifies the court that the person is back. And that's when court has to have a hearing because you've committed the person. And so there has to be a requirement that state's attorney has to prove by clear and convincing evidence again that they are dangerous and need to stay there. So that's a constitutional requirement.
So
We do have go ahead, Martin, and then we have a question.
Partly resolving your concern that we have to see really there for this public safety issue I mentioned. But I forgot that we're gonna get to this part, that we have the agency of human services medical director making sure that compliance with that medical regime, that medication is part of this. So.
Connor?
Yeah, question that's underlined in Bill, not even just the amendment. Is the medical director an existing position, or does this legislation trigger the creation of it in statute? And if so, is there like a corresponding appropriation you need? Or is it just being absorbed with like vacancy savings?
It is not being created in this legislation, but my understanding from other witnesses, I don't have any personal direct knowledge of this, is that the position is currently posted.
It's currently what?
Posted.
Yeah, this was a couple weeks ago, and it's funded.
It was posted before the concept of this.
Yeah.
Trump.
That's what I understand.
Okay, thanks.
Now they'll never find anyone.
Well, that's true.
It's available a little harder. It's a.
But again, just as a reminder for folks, because it's always good to keep this in your back of your mind, that this provision that you're looking at, that the agency is only in effect for 3 years.
Yeah.
At the end of that 3-year period, it goes back to 7.1, which I'm looking at. I happen to be looking at 7.1, page 10, but you go back to the language as the committee had seen it before, which is as appropriate for the needs of the person, mental health, disabilities, aging, independent living, they monitor. So it goes back to that version once the permanent facility is in place in July 1st, 2029.
And we're still talking with folks who have a life sentence, health without bail, all of those qualifications.
Yeah, that is in place in both the interim and permanent forensic facility programs. So that brings us to the next section, which you'll see is section 10. Now this actually, again, we'll be able to look at this very quickly. This starts on page 13. But this is because we were just talking about the people who have been found not competent to stand trial. Remember, forensic facility is also for people who are NGRI, not guilty by reason of insanity. That's what this section deals with, those folks. But all this does is it makes the exact same changes that you just looked at already with respect to the competency folks. And that I'll point you to specifically. It's a few pages in subsection F, which I believe is on 17, maybe it's on 17.
9/11.
Yep. So it's the same changes. You'll see it's the agency, it's on lines 11 and 12. It's the Agency of Human Services Medical Director in consultation with who monitors compliance. The second sentence, line 15, it's upon request from the medical director, the court orders a return. And then line 19, the medical director notifies the court when the person gets back. So same change that you just looked at with respect to the competency population. And that's the only change to that section, section of underlying bill. That brings us over to page 18, which is the forensic facility definitions. And in fact, though, there's no change to that definition of competent can be restored on page 18. But over on page 19, that's the definition of forensic facility. Now you see here that the language on lines 1 and 2, page 19 is where I am of the amendment. Forensic facility means a locked, secure facility that provides a suitable clinical setting where. Now that's where the change is in the version of 7.1 that this committee saw. And as a reminder, will come back into effect on July 1st, 2029. That language is licensed as a therapeutic community residence.
Yeah.
So instead of suitable clinical setting, it would say licensed as a therapeutic community residence. And the idea here, remember, is that, and this may, a committee may recall this, and Katie is a better explainer of this than I am, but the definition of therapeutic community residence needs to be amended a little bit in rule in order to square up with the forensic facility population. So that's going to be happening in the emergency rules. And then as of 2029, I think the idea is it will be a better fit for the requirement to be that the forensic facility be one of those licensed as a TCR.
That's what you've changed. I don't see, we're on page 19, right?
Yeah.
I don't see where you've taken out the language from section 5 in the bill where it's licensed as a therapeutic community residence. I don't see that language in the new language.
For the temporary.
It's taken out from the temporary.
Right,
Because-
this is
This is
the temporary.
a temporary.
Yeah, exactly. It's still in the permanent. It goes into effect in 3 years.
So that brings me to the question though, to that point, Chair. I would like to hear, I don't know if anybody can do this for me, how we get to the point where our correctional facilities, I'm thinking very specifically of the Alpha and Bravo units at Southern, which is where the commissioner indicated that he envisions this occurring. How are we, or let's talk about the correctional facility in Chittenden County where the women will be held. How are we defining those as a suitable clinical setting? I can't get there myself. I can't envision our current correctional facilities. And suitable clinical setting is incredibly subjective. Incredibly. There's no definition. Am I right, Eric?
Correct.
Yeah. So is it a suitable clinical setting because we're providing services, which has been explained to us as the rationale time and again, as we've been taking testimony? I do not define our correctional facilities as suitable clinical settings for forensic treatment. I just don't.
By keeping it in there and saying it is, it gives some, I think, fodder to continue doing it into the future. I'd rather just be honest with ourselves and say it's not.
Yeah,
Maybe we're there.
maybe that's the answer for this
I
interim.
would just strike
Interim
it.
time period, let's call it what it is. We're gonna be housing these folks in correctional facilities, and we're not making any changes. That has been told to us as well. We're not spending money on renovations.
And they're gonna be general population,
Let's be honest.
so that too.
Let's be honest.
Well, what if it's the weasel where it's suitable that is objectionable, then would you change it to forensic facility means a locked secure facility where therapy is provided or something? Like, how would you?
So my suggestion on this is secure facility that provides forensic and competency restoration program.
We are doing that.
That's already in 1 and 2 though, isn't it?
Yeah,
Or at
but
least already in 1.
Yeah, you're right.
So maybe if you want to go that route, just strike that at all. It's just an option. Forensic means a locked secure facility where, and then go into AHS provides for secure conscious restoration by stabilization, treatment, and care.
Right. So it's right, that provides a suitable clinical setting.
Yeah.
Yes, sir. I understand where you're at.
That help, folks, at all?
well, I mean, it's honest.
Let's just be honest with ourselves. Yeah, it's,
Does it help? That's a much bigger question. In the interim, it defines what we're doing. More honestly.
I mean, does not that removal also remove a little bit of the cover that it would provide for the permanent facility? You know, I think I see a
We're
little
keeping
more.
it in, we're keeping it in the
permanent.
7.1, yeah,
Right,
after the sunset.
right.
Because we didn't change it we didn't change it for after the sunset, did we?
No.
Yeah.
So that language can come back in 2029.
Well, so I think that makes it beyond honest. I think that draws a difference between, I think.
I agree.
I think that's.
Yeah.
I have no problem with it.
And the rulemaking would ensure that the clinical services that are being provided is not by contract under DOC.
Yes.
So there's-
Right. Which is really helpful to get this committee on board, Martin.
So you're just saying in that first sentence, then just kill that provides a suitable clinical
Yeah.
setting, just that,
And keep where,
and just go back to from facility to where. All right, thank you. I just wanted to make the right thing. Yep.
or just taking a moment here to, you may notice that when it comes to things I need to remember, I use my red pen. So I see it when I review it.
I know, it's different. So we're just throwing a lot at you, Eric.
No, that's, it's helpful to be specific and clear. Okay. So that brings us to, so we'll strike that suitable clinical setting piece.
Mhm.
And so over, I guess in your version, we're going to look at subsection B next, which I guess is over on page 20, right? Now here is where there's a sentence struck, and it may, I'll read the sentence to you. It will be familiar, but if you want to look at the sentence that's being struck visually, it's going to be in version 7.1, and it's on page 20. Oh, it's not funny. Page 20. It doesn't happen very often. Page 20 of the amendment and the underlying document. Very coincidental. But so here I'm going to read this. This is talking about the general provisions that apply to general standards and rules that apply to the secure forensic facility being established by the Secretary of Human Services. And remember also that this is the temporary piece that we're talking about for 3 years only.
Are you on 3.1 now or 7.2? Or are you on?
Well, I'm on 3.1
Okay.
to start with. So it's on page 3.1, it's page 20.
Yeah.
We're talking about subsection B, which is lines 1 through 7, the introductory part of it anyway. So you'll see the overall principles that are established here. The Secretary of Human Services shall establish and operate a locked, secure forensic facility for the competency, restoration, evaluation, stabilization, treatment, and care of persons who have been transferred pursuant to, and those are the two sections we just talked about, NGRI and competency. Next sentence, forensic facilities, clinical, forensic, and competency restoration services shall be overseen by the AHS medical director. Now, in this version, there is not another sentence there. In the version that came out of this committee, there is a sentence, and I should say the version that came out of this committee, and which will go into effect again in 2029. And that's the guardrail I was talking about. How in the meantime, the idea was, well, in the meantime, DOC has to be a little bit more involved than they will be in the big picture. So the sentence that struck there had read and will read again in 3 years. And actually, interesting, it will continue to read because it will just be on, it will be on the books. It just won't be effective until 5 years from now. And it will say, the Department of Corrections shall not play a role in the forensic facility's operation, the provision of services, or internal security, except to provide security services for this facility at the admitting area and around the outside perimeter of the facility if the facility is co-located on the grounds of a correctional facility. So I know the committee is very familiar with that sentence because we worked it over several times, but it's more the concept, which is that it'll still be there on the books. I don't know if anybody has
In the
ever.
meantime, we're doing it in the center.
Exactly.
Yeah.
And I don't think everybody's ever noticed this. It's interesting and can be confusing. When you look at the green books, let's presume for the sake of this discussion that this is the way it stays for the next 3 years. The next 3 editions of the green books in the supplement, if you look at this section of law, you'll see both printed there. And there are italics that say, here's the version that's in effect until July 1st, 2029. And then below it, you'll see another italic that says, this version will be in effect on July 1st, 2029. And you'll see that right there. They'll both be there. Understood. Yeah. But from an editorial standpoint, sometimes that can be challenging. But that's the idea.
It gets more complicated.
Yes.
Legislators are complicated people.
Well, so are the issues you're trying to address. So it's understandable. It's aren't simple issues and takes a lot of work. Let's see. So where would the next change be here? So we just talked about that. Yes, it's a 3 edition version. I'm trying to juggle here, but the next one is actually right there. Next provision is subdivision 1, just a couple of lines down, lines 8 through 10. That's actually, we'll probably have to change that back because you'll see, or maybe not. So if you look at lines 9 and 10, it's in a suitable clinical setting again. It's the same concept we were just talking about. And in the version that passed and the version that passed, that's in 7.1, it says in a therapeutic community residence, again, which would still be in effect in 3 years, but it's the meantime situation you're talking about. So maybe you,
It's programming in a set, programming where appropriate levels of safety and security.
Just, I think you can just direct in a suitable.
In a
Yeah,
suitable-
right. Yep, makes sense. It's
Line
line eight.
eight, line 9, begins on line 9.
What was the suggestion?
Got it.
Yeah.
Not in a suitable.
I know that, but Troy said something, and I didn't know what the suggestion was. You said.
Just strike, in a suitable clinical setting.
Right.
Lines 9 through 10.
Yeah.
9 onto 10.
So it would just read,
While maintaining appropriate levels
Exactly,
of safety and
exactly.
security you keep.
yeah, yep, that works.
And then where it also, later on, did you say, Eric, later on, it talks about suitable clinical setting?
I don't think so. I think that's it just sort of,
Place?
yeah, the two places we saw, I think, are the only two. Let's see. So that will take us to, and again, we're still talking about the general forensic facility standards and definitions. And in this section, though, we're moving on. This is subsection E. So I believe for you guys, that will be on page 22, line 17. Yeah. And this just adds on line 18, it just adds the AG. This talks about the secretary having to consult with all the commissioners, and this just adds also that they consult with the medical director.
Yeah.
That's the only change there. Then, so that brings us to the next page, page 23. So we're getting there. We're almost done. This is the emergency rulemaking, right? So this is new, and this is effective now. So when you remember, we were just looking at sections that are also effective now, but they get sunsetted in 3 years, right? This provision is effective now. It's the emergency rulemaking, and you'll see that it says on or before December 31st, 2026. So that's, as the chair mentioned earlier, that's when these rules have to get proposed and promulgated. Have to adopt emergency rules that starting on line 11, establish an interim forensic and competency restoration program that shall operate pending the completion of a permanent forensic facility. So the idea is these emergency rules establish the interim program. And it does so, look at the second sentence, emergency rules shall establish for the interim forensic and competency restoration program and consistent with the standards and procedures of 9, 10, 11 of this act. And then it lists some things that have to be covered. So it has to be consistent with these sections you just looked at in 9, 10, 11. In other words, about who gets there and under what circumstances and the involvement of secretary and all of that.
I have a question.
Mhm.
Well, two things. We want to make sure in these emergency rules that the restoration program is not under contract with DOC. We want to add some language to
Right.
that effect.
That's the one we just talked about, though, just so I know. Yep.
I have a question on top, at the top of page 23, where you're talking about the interim forensic facility definitions. Lines 4 and 5, shall adopt rules. Is that in conflict with the emergency rules, or the emergency rules in place for a very short period of time before they establish the real rules? But you got lines 4 and 5 under the temporary forensic facility that we just went through, establishing rules. And then you've got the emergency rulemaking in section 12. So is there a difference there, or is that just an oversight?
I think we hadn't really thought that through. So,
You're doing the emergency rules that will be in place for the interim, and then those emergency rules, as well as section 11 sunsets, right?
yes.
Section 11. Where does it say section 11 would sunset?
It does. That says that on page 25.
Oh,
Line 5.
will be repealed.
Yeah.
So you got two places of making rules. Are you just thinking the emergency rules are gonna cover for that interim? Or are the emergency rules just for a few months until you get the real rules?
No, it's the latter. I think the emergency rules, because the emergency rules remain in effect for the entirety of the 3 years.
Well, that's my question. Is the emergency for the interim? The emergency rules are gonna be there for taking care of the interim.
Mhm.
You don't need real rules for the interim. You know, the emergency rules is a truncated process to get there. And sometimes what we do, you do the emergency rules first to at least get something going, and then you go into the real rulemaking. I mean, then you put in your permanent rules.
Mhm.
So is the thinking you just do those emergency rules for the interim? Because it sounds like you're doing two sets of rules here.
Maybe, and again, as I said, we hadn't really talked about this issue specifically, so I'm thinking out loud here. But to address the chair's point, it might be, one way to do that would be to, right, to, because you will have in the version of this statute that goes into effect in 2029 has that exact same sentence, right?
Right, you may have just picked it up.
Yes, so maybe it should be struck here. But you keep it in
Yeah, you gotta
Right.
keep it in the
the
permanent,
permanent one,
right?
yes,
You gotta keep it in the permanent one.
right? You strike it here completely.
Emergency rules that are, because so you want to strike
Yep.
line 4 and 5.
Yep. I think it strikes me as a good solution. Makes sense?
Yeah, that makes sense.
Yep.
We're helping you, Martin.
You're helping the poor people who are languishing in the DOC consultation.
Touche.
Question for you. I go into it.
What?
For you, it's about process, not this. But are we going to come back later to see the changes, or are we voting on
Well,
what
I
we?
will read this before we go.
Yeah.
want to recess before we vote?
Well, what about the other thing that we're,
Yeah. I know. Anything
Right,
else?
just ask the
I
chair.
just,
So could you make sure you look at the language that's on page 24, line 4 to 6?
I just texted Wendy and said we might be a few minutes late. What lines? Martin,
4 to 6 is what I was trying to, Eric and I worked on.
after our concern yesterday. Oh, okay. Yep.
Yeah.
I was, yep.
Operate with, maintain, that's, okay. That's the HIPAA concern.
Yeah, exactly.
Yeah.
I appreciate that because that's going to be a big issue. That's my hunch. And then we've got the repeal sections. We got the effective dates of the repeals.
Yes, which I think based on our conversation here today, I don't think need to be changed at all. I think they're good to go.
One clarifying question. We came to the conclusion, I think this is for you, Martin, that folks being supervised in the community are gonna be under the supervision of EOC.
In public safety component, there's that additional monitoring by the medical.
Monitoring and in collaboration with,
Ensuring that complying with the medical regime.
does this place them under the supervision of DOC?
I think it does. I mean, I think that's the idea.
Is that a problem for the courts? Okay.
No, we have not heard that that's a problem.
So if there's a violation of conditions that the court has set,
Mhm.
and there's a violation, PNP goes to the court or they go to state's attorney, where would they go?
Or the
So the way it's set up is, they essentially go to the medical.
Yeah.
Then, and they bring the person back into the forensic facility, and then there's a hearing
Okay.
to see if that was appropriate.
Okay,
So.
that's better. So I've had a request from some members of the committee that they want to take a little bit of time on this. What is your process? How does that impact you?
So we're gonna, right now, I'll start our walkthrough in judiciary committee, and I will highlight these additional couple suggestions from you folks. I'll let you know if I get any pushback on any of them. I don't think I will, but I will.
We're trying to help you. We're trying to address concerns of the committee members that here, but also we're looking out for DOC.
Yeah, no, absolutely, absolutely. And then, once we get through that, I'll ask Eric to give us a draft and then hoping to vote it by the end.
Okay, that helps.
So it will be on,
On this afternoon. It will be up this afternoon.
that's. That works.
Thank
I
you.
think it works.
Thank
you,
you,
guys.
everyone.
Thank you very much. Thank you.
Let's go.